Hello, everyone, and welcome to today's CMBA program webinar. I'm Mike Flynn from Buchalter. Today's program is going to involve two separate short presentations, one by Michelle Mirzwa on the HOBR, there's Michelle waving, on the HOBR refresher, just to keep everyone in mind on that very important set of statutes. And then Paula Lieber of CMG Financial. And Paula, do you want to wave? We'll do a presentation, a discussion on how compliance departments can stay strong in the face of what's become an incredibly increased regulatory environment. Before I introduce the speakers, let me just mention that for all of you who are listening, please think about signing up for and attending our December Legal Issues and Regulatory Compliance Conference, December 12th and 13th at the Renaissance Newport Beach Hotel. It's a great venue. It's a fantastic conference. If any of you have never attended before, it's always great. And this year we have a set of great speakers, panelists from the compliance and legal and mortgage industries, talking about a variety of topics, folks who are really well known in California and folks who are national practitioners in those areas. It should be a really great conference. And also, I just wanted to say special thanks to Samantha Gallagher of CMBA, who did all the legwork organizing this and got everything put together and is watching carefully to make sure that none of the three of us speakers make any glaring mistakes.
Thank you, Mike.
So thanks, Samantha. Well, let me introduce the speakers quickly. Michelle is with the firm of Wright, Finley, and Zach, one of the leading real estate and mortgage firms in the state. And Michelle is one of the leading mortgage lawyers in the state. She's been with the firm. She joined their compliance, licensing, and regulatory division in 2015. And for years before that, has spent a lot of time advising people in the mortgage industry in regard to state and federal compliance and regulatory issues. She covers the entire gamut of California, Washington, and a few other Western states in particular, and federal alphabet soup regulations, everything from the Homeowners Bill of Rights to HMDA, RESPA, FDCPA, SCRA, it goes on and on and on. Michelle can talk about, actually tell you what all those acronyms actually mean and explain how they apply. She's serving on the board of directors of the United Trustees Association and is chair of their legislative committee. In regard to CMBA, she's also a member of CMBA's legislative committee and has been, I think, for a few years now, helping us work through legislative issues and identifying problems and helping CMBA's lobbyists work with the legislature to get results that hopefully help the industry. Our second speaker is Paula Lieber. Paula is the VP of Compliance and Licensing for CMG Mortgage. CMG Mortgage is a privately held mortgage banking company that does retail, wholesale, and correspondent lending. And that gives Paula a great perspective on all the aspects of our industry and the compliance needs in them. She started off as a mortgage broker processor and has since moved on to other positions, including sales assistant to post-closing manager. And that really gives her an incredibly broad perspective on the kind of problems she's going to talk about today, the practical problems of dealing with compliance issues from an in-house position. She professes to actually enjoy the role of helping her company find out how to make compliance work and deal with all these difficult issues. And I should add, perhaps most importantly from our perspective, she is current chair of the CMBA Mortgage Quality and Compliance Committee and will be a co-chair of the December conference. And lastly, for me, I'm Mike Flynn. I'm with the Buchalter firm. I chair our resident Financial Services Regulatory Committee and co-chair our Mortgage Insurance Committee. I'm a member of our Mortgage Banking Committee. I'm chair of the CMBA Legal Affairs Committee currently, and I am a former general counsel at PNC Bank and Flagstar Bank and former acting general counsel at HUD. So I have some of the same kind of in-house experiences that Paula has, and we're going to try to share those with you today. But let's start off with Michelle talking about the Homeowners Bill of Rights. Michelle?
Okay, thank you, Mike, for that kind introduction. We're going to just jump right in. We're going to do a refresher course on the California Homeowner Bill of Rights. We'll talk a little bit about its history. We'll talk about some of the changes that have occurred during its lifetime. And then we will talk about some of the more recent changes that you all need to be aware of that will be going into effect, including some going into effect in January of 2023. So first of all, the creation of the bill was of the statutes was through two bills. They became effective in January 1st, 2023. And the intention of these bills was to target certain areas where servicers were apparently lacking in serving the customers with their needs in the mortgage crisis for loss mitigation. So the targets were proper communication with borrowers, restrictions on dual tracking, establishment of single points of contact for borrowers, easy and transparent access to options that are available for loss mit, verification of loan documentation for the right to foreclose if needed, and then enforceability either by a borrower in a private right of action or by a regulator with respect to violations. Okay, so next slide. Statutes were in effect for several years, and then there were anticipated changes. So when the legislation was enacted, it had certain sunset dates in it, which included January 1st of 2018. So it was actually anticipated at the time that these statutes were created that the HOBR would phase into a less onerous process in January of 2018. And so what ended up happening is those provisions did sunset and certain new anticipated versions of these statutes went into effect. And so the problem is that advocates who had been dealing with Homeowner Bill of Rights during the time that it was in its original form realized that the provisions that sunset in many cases were very beneficial to consumers. And they decided that they did not want those provisions to be eliminated. So what ended up happening was very, very odd, but there was a 1-year period during which the HOBR was in its anticipated reduced form. But then, as of January 1st of 2019, most of those provisions were revived in their original form. And so I let you guys know about this because it is possible that you will have available additional defenses to potential violations of HOBR during this 1-year period from January 1st, 2018 to December 31st, because those statutes were not actually in effect in certain versions during that time. So we have a table here. I'm not going to go through it, but what we'll do next is just walk through each statute quickly, just to give you some background as to what the changes were and what these provisions actually require. So the first piece is contact due diligence. So the statutes want the servicer to contact the borrower to assess their financial situation and discuss foreclosure prevention alternatives. And they want that to happen 30 days before a notice of default is recorded to initiate the foreclosure process. So as of January 1st, 2013, there were 2 different tracks. So one section, 2923.5, would only apply to licensed servicers and depository institutions conducting 175 or fewer foreclosures in their preceding annual reporting period. Okay. Then there's another section, 2923.55, which would apply to licensed entities that had conducted more than 175 foreclosures in the preceding annual reporting period, and by process of elimination, also small actors who may not be licensed were unfortunately grouped into this larger servicer coverage. Okay. And so that's one area that is a little ambiguous, but I do want to point it out because sometimes it's not clear whether unlicensed persons fall under the under 175 because they're small. Actually, if they're not licensed, they fall into the over section. So then what happened on January 1st of 2018 is that the distinctions between overs and unders were eliminated. And so instead, all servicers were then required to comply with the revised version of 2923.5. Okay, next slide. As we've seen, that didn't last long, and the two differing means of compliance were revived as of January 1st, 2019. There is a little bit of case law that over the years that has interpreted, how we can defend against some of these claims. A couple of cases here talk about utilizing the borrower's own complaint to defeat the fact that the due diligence contact wasn't made when the borrower says they were in the middle of a loan mod evaluation, but yet they say they weren't contacted. You can use those to defeat those claims. Other cases where conflicting allegations in other lawsuits that can be judicially noticeable can also be used against borrowers to defeat those claims. Okay, next slide. So one of the other areas that it assists in the due diligence process is that for over 175 servicers and the small unlicensed actors, after the notice of default is recorded, another communication has to be issued to the borrower within 5 business days of the notice of default being recorded. So this is real, guys. Notice of default's been recorded. We want to again tell you about your options for loss mit unless you have already exhausted that first lien loan mod process. Similar to these other statutes, this statute was repealed during the year of 2018, which eliminated that requirement for the over 175 servicers. Many servicers just went ahead and continued sending that notice out anyway. No harm, no foul. But as of January 1st, 2019, it was revived by SB 818. Okay, next slide. Single point of contact. So once a borrower requests loss mitigation, a single point of contact is required to be identified for the file. And that person has to be knowledgeable and speak to the servicer's file with respect to the loss mitigation process. They have to be able to communicate process, coordinate documents, have access to the current status, and help them consider all foreclosure prevention alternatives and have access to stop the foreclosure if necessary. This section does not apply to the small licensed servicers. It does apply to the over 175 licensees and small unlicensed actors. We see a lot of these allegations of violations and complaints because even though servicers are technically complying, borrowers really aren't satisfied, really ever, with what they get out of their quote unquote SPOC. They think that you get one person and they have to have immediate access, etc. Well, the statute actually allows that it can be an individual or a team of personnel, and subsequent case law has indicated that the SPOC can change as long as there is one person or a team of personnel who can satisfy these requirements. So I just put in a couple cases here, one indicating that one of the areas where you can get rid of these cases is if no damages are alleged as a result of the failure to properly fulfill the SPOC duties. If the borrower, for example, was able to be evaluated for a loan modification and all FPAs, doesn't really matter if there wasn't a SPOC. They were still evaluated and they still had an opportunity to participate. So no damages. One case, though, did say, a recent case here, Morris v. JP Morgan, did hold that actual damages were sufficiently alleged in the complaint to defeat the demur, and that the demur was improperly sustained by the trial court. So they could survive the demur process. We're seeing that most likely those are going to be then defeated at summary judgment. Much more expensive, but okay, next slide. One of the other areas that is a little bit different than some of the servicing rules that we have on a federal level is there are more expanded acknowledgement requirements. So this code section, again, also only applies to the over 175 licensees or the small unlicensed actors. And it requires that when a complete loan mod application or any document in connection with the loan mod application is received, the servicer has to provide written acknowledgement of the documentation or application within 5 business days of receipt. Now, this is a pretty onerous situation given the short time frame, and so when you're already complying with CFPB rules, you're doing that initial application acknowledgement already. And you're telling the borrower, here's the process, here's the deadlines, here's the timing, here's when your documents may expire, and here's what documents are missing. That's when the completed application or the original application comes in. But this statute now also requires each individual document to be acknowledged. And this is something that a lot of servicers missed, when this was first enacted. And there definitely were claims being brought regarding this. Again, while this was eliminated in 2018, it is back. And so it does still need to be complied with regarding any document received in connection with the loan mod app. Okay, next slide. Okay, dual tracking, another big coverage area for HOBR. So originally, Civil Code Section 2923.6, again, it applies mainly to the over 175 and unlicensed small actors. It existed prior to 2013, but in 2013, HOBR substantially enhanced it. And it included various requirements for stopping the foreclosure process while a complete loan mod application was pending. Doesn't apply if the loan mod application is complete. Doesn't apply to other foreclosure prevention alternatives, only to a complete loan mod application. A lot of issues here. When is it complete? Reasonable time frames specified by the servicer. So it's a subjective inquiry depending on each servicer. A lot of factual issues to deal with. You really cannot defeat these claims via demur anymore. But when you do move forward, again, the plaintiff has to show that any dual tracking actually caused economic damages. And again, this section was again eliminated in 2018, but then revived to its full glory as of January 1st, 2019. Next slide. Okay, also the issue of multiple applications, repeat offenders, is also covered by 2923.6. And so for over 175 servicers or the unlicensed small actors, they do not have to review the borrower again if they have already been evaluated or afforded a fair opportunity to be evaluated for a foreclosure prevention alternative, unless there's been a material change in the borrower's financial circumstances. The change must be documented. Now, this is different than the CFPB rules, which do not mandate reevaluation unless the borrower has cured the previous default that gave rise to the ability to request loss mitigation, okay? And so that's the distinction between the over 175s and the under 175s. Over 175s have to deal, and the small unlicensed actors have to deal with the potential for repeat applications if there's a material change in circumstances. Some case law on this issue. Is divorce a material change? Yes. Is additional income alleged income? It could be, but only if the borrower actually gave the servicer documentation of the income increase. You can say all day long that your income has increased, but if you don't provide documentation of that increase that would materially impact your financial situation, it will not count. Okay. Again, this section was also eliminated in 2018. Could be the basis for some defenses if your violations were alleged during that time, but the full version was revived as of January 1st, 2019 by SB 818. Okay, next slide. Also covered by 2923.6, denial letters and appeals. So there were several requirements in the original version for denying a loan mod app. the servicer had to send reasons for denial in writing, including specifics like how to appeal, and for certain reasons for denial, they had to provide additional supporting reasons. In addition, not just that the investor disallowed it, but why. Not just, that it was a net present value issue, but provide the factors, the inputs, right? So there was a lot more that needed to be provided in those denial letters by the over 175 servicers when this was in effect. And when it was sunset during 2018, a servicer would still have to send a written denial letter, but it just didn't have to be as specific regarding these investor disallowance and NPV content. Again, many servicers continued to comply with the previous version because it was just easier. But if you have a violation, you may be able to use that as a defense. Also in this section, a 30-day right to appeal, okay? This is different than the federal statutes. California gives borrowers more time. That's one of the main things why the consumer advocates wanted to revive this. It gives them more time, okay? So that period, again, didn't exist during the 2018 year, but there were still requirements for appeals in the CFPB rules, allowing 14 days. Okay, again, all these provisions about denials and appeals revived as of 2019. Okay, next slide. Okay, so the alternative dual tracking prohibition that came into effect while at 2923.6 and 2924.18 for the overs was repealed. Only 2924.11 applied to all categories of servicers during that 1 year period. So you just had the one statute to look at regarding the dual tracking prohibitions during that time. I'm not going to go through this in detail, but there definitely were some differences during that time if you feel like you could use that as a defense for claims made during this time period. Okay, next slide. Okay, so essentially the dual tracking provisions in 2924.11 and 2924.18, okay, one for license over 175 licensees and small actors, one for under 175 licensees. Those were all revived as of January 1st, 2019. Okay. And it basically prevents servicers from moving forward with foreclosure when there is a complete low mod application, if a FPA has been approved in writing, if a short sale has been approved by all parties with proof of funds. One thing that we were able to get in to SB 818, which was, I think, a great benefit, is that those statutes were amended to require that the complete application be received at least 5 business days before a scheduled foreclosure. You may recall before there was no time limitation. So a borrower could try to complete their application the day before the sale or submit a boatload of documents right before the sale, and the servicer was left having to basically postpone the sale because they couldn't determine whether the application was complete at that point. Now we've got 5 business days for servicers to be able to get that app in, determine that it's not complete, and still move forward with the sale. And it really limits those people who are attempting to game the system by filing things at the last minute. Okay, next slide. Okay, there's remedies and damages available to borrowers for violations. If there's a material violation of HOBR and it causes actual damages to the borrower, there are 2 code sections, 2924.12 and 2924.19. So one for the overs, one for the unders. If an action is filed prior to the issuance of a trustee's deed, the borrower can get injunctive relief against the consummation of the foreclosure. If they file the action after the sale, they cannot set aside the sale. They can only obtain actual damages, including emotional distress, and there are enhanced treble actual damages or a flat fee if there's intentional, malicious, and oppressive conduct. No ability to rescind the sale. Also, attorney's fees and costs can be awarded to the borrower who obtains injunctive relief or damage award. Next slide. Okay, there was some additional case law that interpreted the ability to obtain attorney's fees. Monterosa indicated that if a preliminary injunction is obtained by a borrower, they can get their fees then. They don't have to wait until they are determined to be the prevailing party in a lawsuit. The Cease case indicated that an order denying interim attorney's fees is not an appealable order. And then Bustos more recently confirmed that even obtaining a temporary restraining order is sufficient to authorize the award of attorney's fees and costs to a borrower. It's not just the preliminary injunction that triggers that ability to get those fees immediately. And this is true even if the TRO is later dissolved because the borrower is determined not likely to prevail. So it's very important for servicers to promptly oppose even a TRO application. So even if you can't get a substantive affidavit from the servicer, you can't get anything out, at a minimum, you want to go there and argue against the imposition of attorney's fees. Yeah, you want to preserve the status quo, but you are not going to want the court to use its discretion to award attorney's fees and costs just because a TRO is issued to maintain the status quo. So that case really caused everyone to kind of get up off and oppose these more promptly. Okay, next slide. Okay, just to kind of address the impact of a repeal and a revival. There was a specific section in SB 818 that addressed the fact that even though the statute was appealed during that 2018 year, it does not, the legislature specifically intends that it does not impact a borrower's ability to file and maintain claims for violations that occurred with that repealed statute during the time that it was repealed. The borrower could still maintain that cause of action. It didn't have to be dismissed if the violation happened while the previous version of statute was in effect. And that was reinforced by this Morris v. JP Morgan case that was just issued recently. Next slide. However, there is a safe harbor. The lender is not going to be liable for HOBR violations if they remedy those violations. Both for overs and unders, there is an ability to correct. So if you correct the violation before you conduct the sale, before you record the trustee's deed, then you're good. And so even if you did violate it in the past, as long as you correct it and give the borrower, their contact, give them their opportunity to appeal, give them their opportunity to apply and even be denied, you can cure those defects. There's a couple of cases here saying that if a notice of default is rescinded, that is sufficient to cure. Also, a more recent case indicated that even if the notice of default was not rescinded, as long as the compliance was had and the borrower or the servicer cured the defect, allowing the borrower to be evaluated for these programs, they didn't have to rescind the NOD. They could still move forward with the sale because the borrower still got what was intended. They were evaluated for the program, they still didn't apply, and only after the borrower got what was intended did the lender proceed to sale. So the NOD doesn't necessarily have to be rescinded in order to take advantage of the safe harbor. And that's the Billispot case. Next slide. Postponement notices, again, sale postponed for at least 10 days, you got to send out a written notice. It was briefly repealed during that 2018 period, but it's back. Next slide. Okay, so here's the new stuff. Just real quick, Assembly Bill 3088. This expanded the coverage of Homeowner Bill of Rights because the legislator wanted to help small landlords who were adversely impacted by COVID-19 and tenants not paying rent, okay? So what they did was they amended the coverage definition in 2924.15. Previously, the statute only applied to first priority consumer loans secured by a 1 to 4 unit owner occupied property. So it's a consumer loan where the borrower is occupying the property. So that was a limitation that we were able to use quite a bit for defense, right? If it's a entity borrower, not going to happen. If it's a second lien, not going to happen. If it's the borrower's no longer occupying the property, not going to be covered. But now this AB 3088 extended coverage to certain non-owner occupied properties that are owned by small landlords. There's criteria that need to be satisfied. It has to be a 1 to 4 unit property. The property has to be owned by an individual or several individuals. Again, no companies need apply. It's got to be people. Property has to be occupied as a tenant's primary residence under an arm's length fair market lease that was in effect in March of 2020, right? This is so that you ensure that it was a COVID impact that was causing, the default. And the tenant has to be unable to pay rent due to a reduction in income resulting from COVID. Okay, so there's a lot of factual issues there. Next slide, please. So basically what this does, it's going to require compliance with all the due diligence, contact, dual tracking, and remedy sections that we just talked about. And it's going to apply for all levels of servicers. Okay. So as long as the qualifying property that meets those other criteria we talked about remains occupied by a tenant pursuant to an applicable lease, the statute is going to cover this property, and the servicer has to comply with the HOBR. So due diligence, dual tracking prohibitions, and remedies. Next slide. Okay. And so again, just so that we're clear, because of the factual issues with whether those 4 criteria apply, a lot of servicers are going ahead and complying with HOBR due diligence, even if you just don't know, is this owner occupied? Is there a tenant and they're not paying rent? You just don't know. So if it's an individual borrower who has a rental property, safest, unless you've got actual documentation that it's vacant, nobody's living there, or there's another reason for the default, you're going to want to comply with HOBR on those. So now, the most recent legislation that amends this, it kind of extends the application and allows small landlords to continue the protections if they've been approved in writing for a loan mod, under some of the COVID impact modifications, or if they submit a complete application on or before January 1st, 2023. So it's going to be applying to all the same categories of persons who were covered by AB 3088, but you also have to satisfy as a borrower one of these other requirements in order to get extended coverage under this enhanced section of HOBR for small landlords. Next slide. Okay, and again, eventually there's no sunset provision, but because there are specific provisions regarding a specific lease that had to be in effect at a certain time, borrowers who had to have, requested a loss mit or loan mod during a particular period, eventually this is going to become obsolete. But right now, coverage is a largely factual issue. It still needs to be looked at if they're a small landlord and they're an individual before you foreclose. Next slide. And just a real technical issue, there were some minor changes by SB 1498, just in case you're wondering, non-material change to substitute DFPI instead of areas where it referenced DBO in the statute. Non-material. That's it. I think that's my last slide. Questions? I know I went a little bit over. I was speaking super fast though. I'm so sorry, you guys. Does anybody have any questions at this point? You can always reach out to me directly about any of these issues. And of course, there's a lot more information directly in the materials if you read them separately. So handing it off.
Thanks,
I
Michelle.
don't see any questions come through, so we should be good. Thank you, Michelle, so much. That was awesome.
Yeah. Now let's go to the other topic, which is how compliance departments can effectively deal with the increased regulatory burdens. We're a little short of time, so my part is to tee Paula up by talking about the regulatory burdens and changed regulatory environment. I'm going to blow through that very, very quickly. And there's a lot of stuff in the deck about specific things that agencies, particularly the CFPB, have been doing that are new, unusual, or areas they're getting into. We're not going to touch on all of those. I recommend you look at it. I'm just going to talk about the overarching themes of what's been going on. So let's go to the next slide. Next slide after that. Next slide after that. Everyone knows who I am, so we can keep going through these. Next slide after that. Let's talk about the environment. There's been the last couple of years a really unprecedented change in the types of pressures faced by compliance departments in mortgage and elsewhere. And you'll notice in this talk, I'm going to talk a little bit about things besides mortgage, not because you care about them particularly, but because they're indicative of how agencies, particularly the CFPB, think now and how they work now, and they're indicative of what's likely to happen with mortgage in the future. And has happened to mortgage recently, as recently as a few weeks ago, when the CFPB issued a request for information about whether it should take the COVID foreclosure loan modification emergency rules and make them permanent going forward in the event for all temporary distressed borrowers. That type of thing is going to go on. We'll talk about how the CFPB is doing it, and we'll use other types of industries as examples of what they're doing. So for the environment, we're seeing an increase in both prescriptive and proscriptive regulations at the federal and state level, very large number of those. We're seeing much more aggressive agencies. I mean, really more aggressive than I've ever seen them, and engaging in tactics that I don't think anybody's ever seen before. Increase in agency open and visible hostility to regulated institutions and individuals. And for people like Paula, a major concern, the specific targeting of executives and chief compliance officers. Go to the next slide. As far as the more aggressive agencies, particularly with the CFPB, more enforcement administrative actions, what we call regulation by inference, the use of social media, press releases, and comments by the director to imply that something is improper conduct, even when there's nothing that says it is, to force behavior on institutions. A good example of this recently was the bank overdraft fees. All the big banks cut back doing it. Many of them eliminated entirely. There was no rule change. There was no formal announcement. It's just the director and other members of the CFPB posted blogs and spoken speeches about how much they dislike it, and the banks got the message. We're seeing an increased issuance of interpretive rules and circulars instead of formal rules. The CFPB in particular is expanding its jurisdiction, expanding what rules mean without actually changing them, just claiming it's interpreting existing rules. That's a big change. They're doing the same thing with examination manuals in the area of fair lending and discrimination. The CFPB traditionally only had a few areas that covered into the area of discrimination, such as ECOA, but it has now announced that using its UDAP authority, it finds that any financial institution engaged in any sort of discriminatory conduct in regard to any financial product, that is a basis for the CFPB to now have oversight of authority and the authority to examine for those type of violations. A really good example of how they are using the non-rule changing methodology to dramatically increase their authority and coverage of institutions, and more active role by Department of Justice. Let's go to the next slide. Agency hostility. You'll see in the slide, I won't go through them, a discussion of how the CFPB got very hostile towards some major trade associations, including the U.S. Chamber of Commerce, the American Bankers Association, the Community Bankers Association, who dared to write them a comment letter saying that perhaps they'd overreached their legal authority by so dramatically expanding their discrimination coverage. The CFPB said some really pretty nasty things about the industry, saying that it was not going to let bad actors get in its way of protecting people, and things that you just have never seen regulators say before. The result was the Chamber of Commerce announced it was going to engage in an active campaign against the CFPB's behavior, and it and the ABA and a few others filed an action, I think a week and a half ago, in Texas, challenging the specific statute and challenging the way the CFPB is using UDAP to expand its authority, areas of authority and jurisdiction. Lawsuit to follow. The CFPB continues these kind of statements. It's really a strange situation. Let's go to the next slide. What does this mean for compliance officers and compliance personnel? Well, we're seeing a targeting, particularly at the federal level, of executives and chief compliance officers. They're being named in enforcement actions. We've seen the CFPB in a couple of major enforcement actions with TransUnion and the next one's on another slide, naming executives in the action, or even worse, when they don't name them in the action, in the accompanying press releases and statements by the director, they are named in those documents and called out, both executives and investors, with statements like they should have known the company was not acting properly. They should have known things need to be fixed. It's pretty unusual to see an agency take on executives by name without having any legal charges against them. It's an obvious attempt at coercion, and we're seeing more of it. And we're also seeing that the executives, and particularly chief compliance officers, are targets of the DOJ settlement process demands. Next slide. Let's go on to the next slide. What is this? What does all this mean? It's interesting because the OCC issued a spring 2022 semi-annual risk perspective. Now, most of you on this call probably aren't OCC regulated institutions, but the ideas are the same, I think, for all institutions in our industry. The OCC analyzed the dramatic increase in regulatory pressures we've been discussing. They acknowledge this requires much stronger compliance and the build out of compliance processes, but they identify a number of factors that make available competent, experienced compliance candidates simply not available. The general lack of people in the job market compared to the number of job openings, the incredible amount of compliance hiring that was done in the last 10 years, and the buildup of compliance departments, the increased number of players in the industry who are creating compliance departments. All of this means that they probably can't hire the people they need. The OCC had no solution for this problem. It just identified it as being so severe, it identified it as a separate category of risk for financial institutions, such as yours. And let's go on to the next slide. Let's go on. This is more what the OCC had to say. Let's go on. I just want to talk about DOJ briefly. The Department of Justice has stated that it's going to expect CCOs, Chief Compliance Officers, to sign certifications of any settlements with the Department of Justice, where the CCOs will certify that steps taken to correct the problem have been reasonably designed to prevent future violations. There's no definition of what that means. There's no definition of how you determine it's been reasonably designed. They have some suggestions, such as creating compensation structures that help encourage people to behave properly, making sure the chief compliance officer is at the table with the executives when things are planned. But those are already things people should be doing. And the question is, what are they looking for now? And what kind of burden is this going to place on chief compliance officers? And what do chief compliance officers do if they are being brought to the table, but they're still expected to sign off? And how do they make sure that happens? So I'm going to stop there with all these horror stories. I could go on for the entire remaining time, plus a few more hours. But this is really very serious, and it creates some really bad situations for chief compliance officers, compliance personnel, and executives to deal with. And now Paul is going to talk about, well, what can you do if we don't have enough people and we're facing all this new stuff? What do we do? So let's go through the slides back to the last two, I believe, slides.
We'll just skip on through.
Yeah.
I think we're all, especially being that there's attorneys on the call, you guys are very aware of the issues and the lawsuits and everything that's going on. But for me to help you know how to work with your clients, I can tell you when I came into compliance, I was very excited. I was like, this is awesome. This is black and white. It's in the laws, right? There's laws, there's regulations, it's black and white. It's so not black and white. It is so gray, and it's shocking how gray it is. And that's where compliance really needs their legal partners. That's for sure. It's just so many pressures, because then you also, besides needing to comply, you have the business aspect. Your company has to make money, and if they comply to the 100th degree, they can have a really hard time retaining the loan officers. How do you tell the story to your staff so that you can retain those loan officers? You don't scare them away, but don't violate RESPA. Don't, all these things you can't do. Don't market incorrectly. Watch your social media. So it's very conflicting about what compliance is supposed to do inside a company, and it's difficult. And, you know, do you have your seat at the table? I think that's a big one, and why Mike and I even started this whole conversation and this idea of doing a session together of the DOJ saying, you know, you're in compliance, you better have a seat at the table. And it helps compliance from the perspective of, hey, did you see, CEO? The DOJ said this. I need to have a seat at the table because I need to know what's going on and I need to tell you the risk. It's my job. And I would say if you're working with any of your customers and they don't have a seat at the table, there may be somebody in between, and they may be sharing everything they're supposed to with that person. They're talking about complaints, they're talking about fair lending, all of the things that they must tell the board. But if that person is in between, that person might not be telling the board everything they're supposed to know. So be careful if there's somebody in between the head of compliance and risk to that board, because you need to make sure that they're getting that information, because you may be surprised if you find out they're not. But let's go to the next slide. So what do we do? Number one, like I was already mentioning, partnering with law firms. We need your support. And it can be, I mean, some things that I find so ridiculous, I've had to go to outside counsel. I need you to just confirm that I'm right, because we get argued with all day long. Everybody else does it. Everybody else, everybody else, everybody else. Something as simple as not ordering an appraisal until after LE receipt and intent to proceed. I have argued that same topic with loan officers for like every few months for the last 9 years. Well, since TRID. But it's just ridiculous that it's that difficult to get. You just have to re-explain it over and over and over, and then you need to have a law firm confirm that you're right, which do I really have to do that? Come on. But yes, in order to get sales to listen. So
Paul,
that's where
I see a lot more clients coming to us with those type, as opposed to the initial, we're building out, how do we comply with RESPA? We've already figured this out, but our, you name it, head of sales, head of operations, whoever it is, won't do this. Can you just confirm we're right? And it puts the law firms in a bit of a difficult practical position, because they represent all sides of the company.
True.
But lawyers need to be, I think lawyers need to think carefully about why they're being brought in, what they're being asked to do. They're not being asked to, and if they feel they can't say to the compliance department, you're right, they need to say that, but it's not their job to come in and say, well, let's bend this so the business people are happy. That's not what they're being asked to do. They're being asked to make sure the company complies with these regulatory protection and oversight requirements. And law firms need to keep that in mind. It's a very dangerous time for companies, and law firms have to have a little broader perspective, I think. Michelle, what do you think?
Yeah, I mean, it is always hard balancing the interests of ops with the requirements of legal and compliance. So, but yeah, I mean, you do have to make sure you protect the company. And, if there's ambiguity, you can explain to the company what the risks are, right? It may mean this, it may mean that. We think it means this, and you know what? The most prudent course is X. But if you want to do this, here are some measures you can take to, minimize consumer harm or the appearance of, So, I mean, again, it's hard to say without a specific issue, but yeah, I mean, the gray area of compliance that's definitely what it is in many cases, and it's sometimes hard for law firms to give an exact answer of right and wrong. It's more like a range. It may mean this, it may mean that. Here are the risks of taking this course. Here are the risks of taking that course, that kind of thing. One thing I found helpful, again, is sometimes going to the regulator anonymously with a client's question may help. Hey, we have a client that wants to do this. What do you think? And again, it may not be binding, right? But it's sometimes nice to get feedback, either from an examiner or from just the general mailbox, either be it CFPB or somebody at one of the state regulators. So that may help, but I don't know. Again, just a couple 2 cents there.
I was going to add in, Paula, to your comments about the board, getting these things up to the board properly, and and you having a seat at the table. When you're a law firm brought in, when there is already something going on, DOJ, you're working on a DOJ settlement or something with the state that's similar, these issues have to be dealt with properly. You have to not only is it proper to get the right result, but you have to document that you're at the table and that sort of thing. And that's where the law firms, I think, being involved have to think carefully about their real role here probably is to help the chief compliance officer and the general counsel make sure things are done right. Because oftentimes those kind of regulatory requirements, giving you a seat at the table, a lot of companies will resist that. A lot of companies will resist legal being involved. And you've got to realistically explain to the powers that be the company what the real requirements are. And this is not an area you can say, well, we can sort of fudge this one or bend it because we know what your company wants to do. They've got to follow the rules. They've got to get it right. And your law firms have to take on that burden of explaining that and backing you up clearly.
Yeah, no, I love your guys' comments because, of course, I don't know your side. I've never been an attorney, so I don't. So all I know is I send out the question and hope I get the answer I want, or that I get some guidance on what the risks are. Michelle, what you were saying about the risks and giving that answer back with, you can do that, but here's your risks. We'd recommend this, but again, here's your risks. Like one topic, LO comp on HELOC. Yes, LO comp does not apply, but here's your risks. Here's where UDAP can come in. Here, because as we know, as Mike was saying earlier, UDAP is, the umbrella of everything, and Chopra is definitely going to use that umbrella for any topic he wants to go over. So definitely give us the risks. Let us know, because some things are a business decision because of the gray area. Some are not the black and white. So we need to be able to, in compliance, be able to share the information up and say, okay, this is what sales wants to do. This is our concern. Here's the risk with doing it. Make a decision and then document. Okay, Mike's saying documenting. Please remind all your clients, start documenting now if you haven't already. Like, don't wait for a fancy way to document. Just start it now, because if you don't start taking notes now, taking your minutes, making sure the board has minutes, that will be an issue. We must document. You find an issue, how did you resolve it? When did it happen? Going back and trying to figure it out through your emails takes a long time. Okay, so besides all of the work that we need your help with, your clients could also, of course, use technology to help with compliance. There's a lot of different technologies out there to help, like especially fair lending. You need to have your clean HMDA data. You need to analyze that fair lending, analyze that data. You do need technology for that. That's pretty difficult to do without technology, especially to compare with your peers and to see where you stand. It really helps to have a partner for that. Then there's your other service providers that often have attorneys as a part of it. You Crosscheck or MQMR, companies that can help you with your audits, help you with risk assessments, and give you that overall view that can assist you with it. Because you really need a combination of all of these things to be able to handle compliance at a company. And then, of course, you need your staff. And that's one of the big issues that Mike and I have talked about. What do you do when you can't hire anybody? Right now, we can't hire people because we can't afford to, right? And we're defending every position we have because compliance doesn't make money for the company. We're saving money, but it's hard to monetize that. How do you say, I saved you $1 million this year? How do I say that? I mean, maybe I can off of tolerance cures. We saved you from TRID tolerance cures, but there's a lot of things, state exams that you could have gotten in trouble, but because we were there and we made sure it was done compliantly, you did not get in trouble. You can't really monetize it, but you have to defend your positions and make sure that you have the right staff in there. I mean, the good thing now for your clients, if they don't have the top-notch people in compliance, they could potentially find ones that have been laid off. There are companies that are definitely needing to lay off, companies that are closing, and these people could be great out there, and then you might be able to hire them. So if you can, right? If you can replace your staff. But there's also training opportunities. There's MBA's CMCP. which that's great to have your staff go through to make sure they get that whole alphabet soup. That is really difficult, how much you have to know in compliance, from your HMDA to ECOA to TRID to UDAP, marketing, social media. There's a huge range of things for compliance to know. So they definitely need that training, and that can be a big help as a CMCP. Yeah.
I had a question for you. You know, as a result of and during the last crisis, the regulators really pushed everybody to have compliance be sort of a really standalone, pulled out of the business function, an independent function, which is kind of like legal is, and you know, oversee the business that way. But now, even the OCC seems to admit nobody, if you're really growing or you have more operations you have to get compliant with, your compliance department can't grow to be able to be that hands-on. Do you think it's practical to think about going back to the idea of compliance, sort of, there's embedded people in the business who actually know the operations well and are the first layer, and the compliance oversees them and tests them, as opposed to compliance doing all that work itself? Is that realistic? Can it help?
There's definitely differences between how companies have their compliance and their risk, whether it's totally separate, whether the disclosure desk is in compliance or separate in an operations. There's a lot of different ways you can structure it. Compliance, ultimately, you know, with your CMS, we have to be able to monitor. So you at least need to have some people that are not right in the production, because you need to monitor that. So you do need to have that separation, or have that internal audit, or use your outside service provider for auditing and monitoring what your people are doing. So it's good in both ways. You need people in the production world that understand compliance. Those are my favorite people in operations and IT. I have some people that have compliance brains, and I love it. They're like, but wait, I don't know if that's a good idea. Let's go ask Paula. And I love that. Even if they can just wonder if that would be okay and then come and ask. Yeah, I mean, you also may need to take operations people with the right skill sets and train them in compliance. Maybe they need to come out of operations and move into the compliance world because they have those skill sets. They can research, they understand how the loan flows and how the system works.
Are you seeing any increase in training of the line personnel, of operations personnel, to try to avoid these kind of mistakes? Because, you know, we're in a world now where even one mistake that is a complaint will turn into an exam.
Mm-hmm.
And
yeah.
So are you seeing people doing more training, or is that something they think isn't going to help them? Or?
Well, with it being slower, I would expect everyone's getting trained, right? They don't have as many loans. They should be getting trained constantly. Why am I still seeing some of these errors? But that's part of my job, though. I partner with training. When we keep seeing something that's not working right, we get with the training and we say, let's make a job aid. Let's make a video. Can you make this video and teach them how to do something? So your training department, if you have one, which hopefully you do, at least somebody that does training, you partner with them in compliance, and that's how we can get that going. But that it does come from typically compliance pushing to make sure that training goes out. Okay. But I know we are at the last 2 minutes. Did we get any questions?
I don't see any questions that have come in yet.
I do want to give one last plug, though, for the conference. Tell your clients, and please, I hope all of you are coming. Tell your clients to come to the conference, where our whole goal is to really make sure that we're giving great information, we're making it interactive, giving people a chance to talk to each other, discuss how are you implementing, how are you handling. That's a big piece for us in compliance. I thrive off of networking with people and talking to them about, okay, my salespeople are insisting that we do this type of co-marketing. Are you doing it? Because they say everyone else is. So are you actually doing it? How are you mitigating your risk? I mean, it's a wonderful way to be able to talk to each other and, you know, and not getting yourself in trouble. Nothing's an email, right? We're just saying, I heard somebody got in trouble for this. Let's talk. I mean, this is a great way to network. So tell your clients, come to the conference, December 12th and 13th.
We're going to have a lot more interactive sessions, including this last topic that Paul and I talked about. we're going to have it at the conference, but it's going to be interactive, not us talking at you, but encouraging you to talk to us about how you're dealing with and perceiving these problems. And we think that's going to be really great. So we encourage you all to attend. Thank you for attending this. Michelle, Paula, thank you very much. Samantha, thank you very much. And
You guys.
I think our time is up. We're exactly at the top of the hour, so I think our time is up. And thanks, everyone.
Thank you, everyone.
Take care.
Bye.